Hello everyone, my name is Natalia and I am a real estate attorney here in the state of Florida, and I wanted to talk to you about estate planning. Not just any kind of estate planning, but the typical comment that us attorneys that do estate planning here in the state of Florida get, which is, but I just own my house and I just need a simple will. And I just want to get clear with everybody that that is a huge misconception, the whole concept of a simple will, particularly if you own real estate in the state of Florida. So first thing first, there's no simple thing as a simple will. It doesn't exist. Your facts and circumstances really vary from household to household, and what you need really depends on your circumstances. And so downloading a form from LegalZoom or getting it from Office Depot is just not going to protect you in the way that you think it is. And today I want to explain a little bit about why. I also want to let you know, for more of these videos, we have videos on both estate planning and real estate investing here in the state of Florida. Subscribe to our channel. All right, but let's get right to it. Estate planning. And I want to talk about owning a house. So if you are like the majority of people in the United States, your biggest asset is your primary residence, your home, where you live. It's where you put in all your money, where you signed up for 20, 30 years of payments, and what you plan to pass on to your heirs. So I want to say a little bit about Florida and primary residences. Here, your house is considered to be your homestead residence. And what that means is that your house, where you live, where you've made it a permanent residence, is protected from creditors under certain circumstances. This applies to U.S. citizens and U.S. residents, as well as to their U.S. citizen children, spouses, or U.S. residents, children, and spouses, or other heirs. So since your house is your homestead, it has that creditor protection, but there's also limits on who can inherit homestead houses. So if you're married or if you have minor children, there are limitations on who you can leave that property to. Number two, simple will mistakes relating to homestead residencies. So the first very common mistake is that they have property titled in their name and their spouse's name as husband and wife, wife and husband, husband and husband, wife and wife, and they think that that's okay in terms of that'll take care of everything. My spouse will pass away, or I will pass away, and it'll just go to them. But they fail to consider, what if your spouse predeceases you and you pass away? How is that going to pass along? And what limitations are there on this if I have children or other heirs at law? So you really need to be careful and make sure that you just don't skip on your homestead because you think, well, it's disposed of in my deed designation, and therefore I don't have to think about it. So big mistake. Number two, directing a property to be sold. Okay, so if you have homestead and you think, well, it'll just be easier if I just make my kids sell it, and that way they each split the money, however many ways. Well, the bad thing about directing that is that you've immediately made that asset a cash gift rather than the gift of homestead. And by doing that, you've opened up that asset, which would have otherwise be protected from creditors' claims, ripe and open to claims of all creditors of the person that passed away. So you need to make sure you're not putting that kind of language in there. Same thing goes with leaving your homestead residence as the residue of your estate, and then putting other clauses in there that say, oh yeah, and your personal representative is going to have to pay the costs and expenses of the estate from the residue of the estate. That's once again opening up the door for creditors to touch that homestead, which would have otherwise been protected and exempt from creditor claims. And number three that I want to talk about pertaining to homestead property. Can somebody waive their right to receive a homestead? And yes, they can. So if you are in your second or third marriage, you should really consider waivers. And those are waivers signed by the new spouse to that homestead property, particularly if you've owned it for many, many years prior to marriage, and you want it to go to your adult children, consider it in a prenup, a postnup, or in a deed that they are waiving their homestead rights to that property so that you can devise it to the children that you wanted to go to, and they don't have to deal with stepmom or stepdad in terms of where that house goes. All right. For more videos like this, please subscribe to our channel. We are jam-packed with information that's going to protect your assets here in the state of Florida and your estate. And my name is Natalia Willette, and I'm a real estate and estate planning attorney here. Good luck out there, investors.